Good morning, everyone. My name is Clay Creps, and I'm a partner in the Labor and Employment Group at Tonkin Thorpe. I'm your speaker today. Before I get into the substance of what we're going to be talking about today, our marketing people want me to read something to you. Welcome to our webinar, Legal Considerations for Employers Related to Protests, Racial Injustice, and Political Speech. My hope is to provide you with practical advice for your business to thrive during this pandemic. If you have questions unique to your business, I invite you to reach out directly to me or the Tonkin Thorpe lawyer you normally work with to discuss your specific situation. Let me pause and make a note about this format. First, please know we are actively recording this webinar. You do not need to sign a disclosure, and no private information of yours will be shared. Know, however, that should you choose to participate in our Q&A section, your question may be recorded in association with your name. Feel free to submit questions in the Q&A section of your Zoom app. I will do my best to answer some of those questions. I want to be sure to have time for the presentation, so if I don't answer your question right away, please wait for the end. Because the situation we're involved in is so rapidly changing, I frankly may not know the answer to your questions, or your questions may be too nuanced or specific for me to address in this webinar format, and I invite you to reach out to me directly in that case. I'll conclude with a Q&A session, and we'll try to hit as many of these questions as we can. Additionally, we welcome any feedback you may have after this webinar. If there are topics you want to hear about more, tell us. We hope to be a source of information for our business community throughout all of these challenging times and plan to hold additional webinars going forward. Finally, the information presented here is as of June 18, 2020, and is not intended to be legal advice. Let's get started. The protests in the wake of the murder of George Floyd are bringing an awareness of racial injustice, which is frankly unprecedented and long overdue. This is a volatile time and emotions are running high. People who never before were politically or socially active have become so. And these issues can't help but invade and impact the workplace. Now, my goal today is not to take a stance on those issues. While I have strongly held beliefs about these issues, this is not the forum to address those. My goal is rather to provide some guidance to help employers navigate the impact of these issues on the workplace. And since we're still in the midst of the COVID pandemic, what constitutes the workplace is a fluid concept. Some people are working in a physical workplace, while others are working virtually. And in the latter case, the virtual environment literally constitutes the workplace. The myriad of emails, Slack messages, texts, Zoom meetings, and the home work environment constitute the workplace. This makes navigating these issues even more complicated. All this being said, however, I do have to say I come to this topic today with some trepidation. I'm wading into an area which can be sensitive and regarding which many of us have strong feelings. Many of us have unfortunately been woefully ignorant about these issues in the past. I know I personally have much to learn and am actively trying to educate myself. That being said, I know I'm behind the curve. So it is possible that during this presentation, I may inadvertently say something which sounds insensitive or ignorant. Not in discussing the legal parameters surrounding these issues, but in providing the context in which these legal parameters apply. All I can do in that case is ask for your patience, for your grace, and for your understanding that as a 60-year-old white man, I am trying to bring my thoughts, actions, and comments into conformity with where my heart is. So today we want to look at how these issues might come up in the workplace and impact the workplace, and what an employer can and cannot do when they do so. We'll be looking at three primary topics in the context of the workplace: political speech, the protests, and how an employer might respond to racial injustice. Our first topic is political speech. This can be a touchy issue and it can be very dangerous in the workplace. Conversations about political issues can often focus on race, sex, religion, other topics, and therefore can provide a potential ground for discrimination or retaliation complaints. In the current context we're living in, we're almost certain to see discussions involving race in the political context. Yet in a survey done in 2016, it was found that only about 3% of companies had an official or even unofficial guidance or policy about talking about politics in the workplace. So the first takeaway that I can give you in this presentation is that if you do not have a policy, it is probably a good idea to draft one along the guidelines that we'll be discussing today. Obviously, those of us at Tonkin would be happy to help in that regard. So the first question that arises is political speech protected in the workplace? Stated another way, can an employer regulate what employees say in the workplace from a political standpoint? Well, let's talk about the law. One of the principles on which political discourse in the United States is based is the concept of freedom of speech. From our earliest years, all of us have been taught that there is this concept of freedom of speech. And many look at the issue of speaking about political and social issues in the workplace through this lens. And of course, this concept comes from the First Amendment to the Constitution. But what does the First Amendment say? It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or importantly for our discussion, or abridging the freedom of speech. And then this right was applied to the states through the 14th Amendment. So does this amendment mean that an employer cannot abridge or restrict freedom of speech in the workplace? And the answer to that is generally no, that isn't what it means. The First and 14th Amendments deal with government action restricting the freedom of speech. They do not address and therefore do not protect freedom of speech in a private workplace. The state and federal governments have enacted legislation which has selectively provided some freedom of speech in the workplace. Think of whistleblower laws. An employee has freedom of speech to blow the whistle. Think of rights under the National Labor Relations Act to engage in concerted activity. An employee has freedom of speech to talk about working conditions and things of that nature. But generally, the right to freedom of speech does not extend to private employers. So let's explore the parameters of this. Can an employer regulate political speech in the workplace? The answer is a resounding yes. An employer can even bar political discussions entirely. An employer can discipline or discharge an employee for legitimate business-related reasons, even if the conduct involves political expression at work. Now, this includes expressing an opinion in the workplace, expressing an opinion over email. For example, if the expression interferes with an employee's work, disrupts coworkers, or infringes on business objectives, discipline can and would be appropriate. But be careful. The application of that must be even-handed and not based on a protected characteristic. What am I saying? What I'm saying is you can't decide who you're going to allow speak freely about political issues in the workplace based on race or gender or sexual identity or any of those kinds of concepts. A related question is, can an employer require employees to support the employer's political views? Many companies have owners and executives who hold strong political views and want to use their company as a means of expressing these views. So the question is, can an employer require an employee to support that? And the answer is almost universally no. Under federal law, there is a small exception that allows corporations to attempt to persuade a restricted class of executive personnel to vote for or against a candidate or cause or measure, but that is extremely limited. Under federal law, the law is generally an employer cannot try to persuade an employee regarding these matters. Looking at state law, there's even more protection for employees. In Oregon, the Worker Freedom Act prohibits employers from forcing employees to attend political meetings or distribute political communications. That can be important when we have an employer who wants to get a political message out. In Washington, employers cannot interfere with an employee's efforts to support or oppose an initiative. They can't discriminate against employees because of their support or opposition of a candidate, a party, or other political activity. And in Washington, an employer cannot use payroll contributions or salary increases for the purpose of funding political activities or candidates. The legislation in California is even broader. Employers cannot prevent employees from participating in the political arena in any capacity. An employer cannot direct the political activity or affiliation of an employee. An employer cannot discharge or threaten to discharge an employee for engaging or refusing to engage in political activity. So what's our takeaway here? Our takeaway is that employers should not press employees to vote for a particular candidate or a particular initiative or take a position on a political issue. And employers should not use threats of adverse employment action to influence an employee's vote. Now, we talked about employers that want to get a political message out. Could be supporting a candidate, could be supporting a cause such as Black Lives Matter, given the environment that we're in. In fact, we know that many businesses are doing this. You need to be careful in this regard, however, though, because requiring an employee to engage in work on behalf of the employer in support of a candidate or a cause could be construed as trying to influence how an employee views a political issue or how they might vote on a political issue. What I mean is, if an employer directs an employee to do something, such as drafting statements, posting on social media in support of a candidate or cause, putting up posters, trying to require an employee to attend a rally or a protest, and the employee refused to do this and was then disciplined, that would clearly run afoul of the state laws which I previously read to you. So what do? We know we have employers who want their employees to facilitate the business taking a stance. This is where reality gets difficult when it comes up against the law. Requiring an employee to do that and disciplining the employee because they will not do that runs afoul of those laws. Another question: can an employer prohibit political campaigning in the workplace completely? Now, the answer is a resounding yes, and an employer should do so through its non-solicitation policy. Most employers have non-solicitation policies which prohibit employees from soliciting in the workplace. That's no different when it comes to political issues, and that is how an employer should address political campaigning at the workplace. Another question is, can an employer prohibit political displays at work, such as buttons, signs, or posters? Well, the answer again is yes. This again would be done through the non-solicitation policy and an employer's dress code policy. I want to give you a caveat though with respect to buttons or shirts, things of that nature. Under the National Labor Relations Act, employees have the right to display union insignia at work. So while an employer could prohibit buttons relating to political candidates or causes, they can't prohibit the display of labor union insignia at work. A big question is, can an employer restrict an employee's off-duty political activities? This is a dangerous area. We discussed these state laws earlier. These provide protection to employees. They say basically hands off. So employers need to be careful not to discriminate against employees for engaging in political activity outside of the workplace. I'm going to talk about a few examples. And even though this appears to be the law, we know that employers do wade in this area when an employee engages in what might be viewed as particularly egregious activity in pursuit of a candidate or a cause. And we'll talk about that in a little bit. Now, an employer is perfectly permitted to prohibit any political speech in the workplace, but an employer also can permit political speech in the workplace. Again, this is a dangerous area because discussion of these political issues can stray into a discussion of protected characteristics such as gender, such as age, such as race. For example, comments that a certain person should not be the president because the individual is old, or because the individual holds a certain religious belief, or because the individual is of a certain race, can be considered discriminatory and in fact even harassing in the workplace. And you probably want to put a stop to these types of comments. In other words, we know what harassment is in the workplace. It is comments based on a protected characteristic that are severe and pervasive and interfere with an employee's ability to do the job. So if you had somebody who was constantly making comments related to race in the political context, this could be viewed as racial harassment in the workplace. It's a tough topic. These are dangerous waters. You can only try to do the best you can and try to keep these points in mind as you navigate this. So let's take a look at a couple of examples from recent days. The first one I want to look at is Starbucks. About a week ago, maybe a little more, Starbucks came out with a statement that said that it was going to prohibit its employees from wearing masks or shirts supporting the Black Lives Matter movement. Was that legal? Absolutely. An employer can restrict political speech and has a right to enforce its dress code policy. Of course, the enforcement of that policy must be done in a neutral, non-discriminatory way. For example, if the employer prohibited Black employees from wearing a BLM shirt but permitted white employees to wear Blue Lives Matter attire, that could well be considered discriminatory. Maybe a more realistic example is, what if the employer didn't make this distinction on the race of the employee, but just said, I'm not going to permit Black Lives Matter attire in the workplace, but I will permit Blue Lives Matter. That could be problematic on at least two grounds. It can be seen as making a distinction based on race, which could be problematic, particularly at this time, and I'll get into this a little later. There's a heightened awareness now of race issues. And I think we're going to find that people feel much more empowered to come forward to discuss those race issues, and particularly where they see a problem in the workplace related to race. I think that tells us that caution needs to be exercised in the workplace. Excuse me. But the second reason that not permitting Black Lives Matter attire, but permitting Blue Lives Matter attire could be a problem in the workplace is that could be seen as attempting to influence an employee's position on a political issue, which is prohibited. That is, if you disciplined an employee for wearing a Black Lives Matter shirt, but not a Blue Lives Matter shirt, that could be seen as attempting to influence how the employees think and act on those issues. Well, then Starbucks reversed course and decided to print Black Lives Matter t-shirts that its employees could wear. Again, is that permissible? Absolutely. Under an employer's ability to enforce the dress code, there's no problem. Further, although an employee can prohibit political speech, an employee can also permit political speech. Now, where a problem could arise is if Starbucks made wearing the t-shirt mandatory rather than permissive or voluntary, or if people who chose not to wear the shirt were somehow subjected to untoward actions or pressure in the workplace. Again, that could be because it could be seen as requiring an employee to espouse a political point of view, which is prohibited. Another example we have involves the Ford dealership, Demuro Ford. I don't know if you saw this in the news recently. Demuro Ford fired a highly ranking employee because of social media posts this employee made on June 7th. So here we get into the issue of activity outside the workplace. Clearly, posting social media posts, not during work hours, is activity outside the workplace. Well, Mr. Lostrito kicked off his rant on social media, questioning the motives behind the recent protests and suggesting that a more effective tack would be to pull back the curtain on what the government has done to, quote, our economy because of COVID-19, as opposed to one, and I'm quoting, sorry, one thug who got caught breaking the law and paid the ultimate consequence for his actions. Well, he didn't stop there. He later made disparaging remarks about Black people in subsequent posts, including using the N-word. And he even wrote that Portland City Commissioner Joanne Hardesty, who, as you know, is Black, should, quote, go back to Africa. Wow. Well, let's examine this. Is there political speech here? Absolutely. His comments about the government's response to COVID-19 is political speech. Further, comments about protests could be seen as political speech. Was the political speech in the workplace, even given our expanded view of the workplace? And the answer is no. It wasn't in the workplace. So could Demuro have fired him solely for the political speech? Probably not. This could be seen as trying to influence how he and others took political stances or voted. Is that going to stop an employer from taking that action? No. Most employers are going to take their chances. So is this termination likely to stand up if this employee were to sue? I think so. And I think so because he engaged in racially discriminatory speech. Using the N-word and telling Hardesty to go back to Africa, that's race discrimination. I'm assuming Demuro's social media policy prohibits such discriminatory speech. Therefore, the termination is likely on solid ground. So let's look at our expanded workplace, things you might not have thought about, and expand our examination into that area. So someone's on a Zoom meeting, much like I am here. What if they have a Confederate flag on their wall behind them in their house? What if there's a poster for a particular candidate? What if they're wearing a shirt or a button espousing a political view which is visible in the Zoom meeting. What can the employer do? I mean, it's in the person's house. Well, there are no cases I'm aware of at this point, but I think the employer has the right to regulate that speech. Even though the location is the employee's home, it is still the workplace by virtue of the Zoom meeting. And I think an employer legally can take steps to require employees to remove or somehow block such political speech if the employer chooses to do so. Okay, let's change gears and head on to protests. I don't have a lot to say about protests. The first thing is, we know that people are becoming much more politically active. We know that people are engaging in protests. What about taking time away from work to engage in a protest? Any time away from work to engage in a protest must be in line with an employer's attendance policies. An employee does not have a right to miss work in violation of attendance policies to engage in protests. There's nothing about the exigency, the political climate, or the nature of the view held in regard to those that allows an employee to simply walk off the job and go engage in a protest. If an employee does so, they can be disciplined for that. Some of you might be experiencing that currently in your workplaces. Secondly, is conduct outside of work in connection with the protests protected? Well, not necessarily. And this is another gray area. For example, I don't know if you saw, but a few weeks ago, FedEx fired an employee for conduct at a protest. In this instance, a white employee of FedEx knelt on the neck of another white employee in a clearly mocking manner in front of Trump yard signs. The obvious point of this conduct was to minimize the importance of what happened to George Floyd. FedEx fired this employee. Now, an employer can take disciplinary action against an employee for conduct which can reflect poorly on the employer. We've seen this. High-ranking employee goes out and becomes intoxicated, engages in behavior which leads to criminal charges. Employers can discipline and discharge for that. What about here? An argument can be made that regardless of how repugnant the conduct may have been, it still constituted political speech outside the workplace, and disciplining for this could be seen as the employer trying to influence that employee's or other employees' political position. So what do? You act knowing what the law is. You act having knowledge of the environment in which you're acting, and you act based on your conscience. I think that what we're going to find is that if the law does not already permit employment action based on this kind of conduct, that it may evolve there soon. We know employers are going to take action against employees who do this, and I think the best argument is this has a poor reflection on the employer, and it's on that basis. Lastly, let's talk about racial injustice. It appears self-evident to me, having been practicing employment law for 30 years, that racial injustice occurs in the workplace and outside the workplace. For me, that's a given. The events following the murder of George Floyd can provide an impetus for re-examining the workplace for evidence of racial injustice. As recently as this past Saturday, I read an article that had reports of evidence of racial injustice in the workplace. For example, 14 current or former contributors or employees of Bon Appetit, the magazine, reported a toxic culture of microaggressions and exclusions on the basis of race. Another company called Reformation, which was founded in 2009 and focused on fashion, had its female founder and CEO resign after allegations of racism from past employees emerged on social media. These employees claimed the company had a, quote, horrible culture of racism and pushed out, silenced, and degraded Black employees. Lastly, as another example, the editor-in-chief of Refinery 29, which is a digital media company, stepped down after backlash over lack of diversity and claims of racist aggressions. In light of this, I think we can expect that employees are going to have a heightened awareness of issues of racial injustice in the workplace, and again, may feel more empowered to speak about what they perceive to be improprieties in the workplace based on race or, in fact, racial injustice. I am therefore counseling my clients that it is a good idea for employers to take another look at their practices and their cultures to try to ensure that there is no racial injustice occurring. Let's take another look through a more heightened lens about what we're doing in the workplace when it comes to issues of race. Now, this could include, first and foremost, listening to your employees. If someone comes forward with a concern, listen to them and take action if it's appropriate. Examine hiring practices, evaluation and promotion practices, and pay practices to see if there isn't overt or covert racial injustice occurring there. I'm also recommending to employers who want to go even further to retain a consultant to study the workplace, to make sure these problems are discovered and rooted out. The last thing I want to discuss today is the issue of diversity, equity, and inclusion committees, or task forces in the workplace. Many companies have had such committees for some time now. My firm has had a D&I committee for a number of years. However, in light of recent events, many more companies are exploring this. One of my clients has been in touch with me about trying to set up such a committee. They're asking questions like, well, what should the committee look like? Who should be on the committee? What should its purpose be? Should we hire a consultant to help us set up such a committee? All of these are good questions. I first want to say there obviously is no legal requirement that you have any such kind of committee in the workplace. But I do think it is a good good idea to build morale and to make sure that the company is doing what it can do to address these issues. So what are some considerations in establishing a DE&I committee? Number one, establish clear goals. What is the goal of this committee? Is it to identify issues in the workplace? That's a legitimate goal. Is it to educate the workforce about DE&I issues? That's also a legitimate goal. But figure out what the goal is. I think it is important, if you're going to have such a committee in the workplace, to ally with someone with decision-making power. It's good to have someone from management involved who can assist in the implementation and furthering of any decisions and actions the committee recommends. Well, what about the makeup of the committee? Well, generally, you should have people who are interested in the topic on the committee. Should it be only people of color? One of my clients wanted to restrict its DE&I committee to only people of color. I don't recommend this for a couple of reasons. If management says only people of color can be on the committee, isn't that race discrimination? And secondly, it inherently runs counter to the idea of the committee, which is diversity, equity, and inclusion. I want to say a word, go a little bit off topic here, but just for a moment, and talk about the Juneteenth holiday, which is tomorrow. We've gotten some questions from clients about how to implement that and what can be done. And a client, more than one client, suggested giving the time off paid for people of color, but not other employees. Again, I don't think that's a good idea. I think, in fact, that could run afoul of race discrimination laws. Now, depending on how large a purpose the committee has or simply how lost you feel in creating such a committee, it may be a good idea to engage a consultant to help set up the committee, establish goals and procedures. On the next slide, I have included the names of several organizations which specialize in this. The first is the Center for Equity and Inclusion. This is a Portland-based company. You see the link to the website there. Another company is Paradigm, and you can see the link to the website there. Lastly, we have Courageous Conversations, which is another company that engages in consulting with companies to establish DE&I committees. I am not recommending any of these. I am simply giving them to you if you would like a resource that you could reach out to evaluate what you're doing in this regard. In connection with the DE&I committee, I've noticed that employers and my own law firm are also establishing support groups, a group for people of color to have a safe place to engage in discussion. Perfectly lawful and probably a very good idea. Another idea is to create an ally group, the purpose of which is to educate those in the workplace who want to be an ally during this time. My firm has done that as well, and I'm going to be a part of that, and I'm looking forward to it. Well, that's what I have for you at this time. In that event, I want to thank you for joining me today. I hope this was informative. I hope it's given you a lot to think about, and we look forward to seeing you again at another Tonkin webinar. Thank you.